The Supreme Court has basically given the lower courts in this case an incomplete and told them to try again to decide whether the affirmative action program at the University of Texas at Austin is constitutional. The court said that affirmative action can be allowed constitutionally only in very narrow circumstances, so it basically raised the hurdle for the University of Texas to clear.
All right, welcome to the Steve Malzberg Show, ladies and gentlemen. A big news day. We have the Zimmerman trial, we have the Snowden case, and we have the Supreme Court decision today dealing with affirmative action. Joining us right now is our friend Alan Dershowitz, of course, Harvard Law professor and attorney. Hello, sir. How are you again?
Hey, nice to talk to you. Thanks for having me on.
Oh, always great to talk to you. Okay, so we heard them say that the court kind of punted. It was a 7-1 decision, although Clarence Thomas wrote his own decision going along with the majority, but kind of objecting in a sense. What do you make of the case that basically told the University of Texas and universities that you could use race in admissions, but you have to exhaust every other possibility first?
Well, I think that's the right decision. Anytime you want to use race, positively or negatively, you really have to have a very, very good justification. The presumption should always be judging people on the basis of their character, as Martin Luther King put it, not on the basis of race. But there can be exceptional situations. And I think what the court said is the Fifth Circuit opinion that basically said all you have to do is have a good faith basis. Well, of course they have a good faith basis. You're not going to accuse a university of not having a good faith basis. They're not trying to do it on racist grounds. So they turned the light from green to yellow, and they said, just, do it cautiously, go slow. If you do it smart and you come up with a justification, we'll let you do it. But you have to show that its glove fits the situation.
Are you surprised that it was a 7-1 decision? Of course, Elena Kagan recused herself, but 7-1 is kind of rare, especially in major cases such as this.
Yeah, I know Elena Kagan fairly well, she having been the dean of my law school, and it wouldn't surprise me that it was really a 7-2 decision, that if she had participated, she might very well have gone along with Justice Ginsburg on this. Although, she's a very, very sensible woman, and she might say, look, the nation really wants to see a good justification for the use of race. It doesn't surprise me. I think for many on the court, probably, to everything there's a season. And there was a time in American history where race-based affirmative action was crucially important. And there are those who now think maybe we're beginning to see the end of the need for that, and maybe we're going through a transition period. Also, this is a court that likes to duck issues. It may very well, at the end of this week or next week, duck the big gay rights and gay marriage issues by saying it's a matter of federalism, a matter of California state law. We may not see big decisions coming from this court for a while.
Now, there is another affirmative action case coming, I believe, in the next session, so it's not the end of affirmative action, and certainly throwing it back to the lower court and the way they have thrown it back opens the door for more appeals to the Supreme Court on this. Whether or not they'll take it, we don't know, but am I correct that this kind of leaves the door open, so it leaves it open enough for people to try to get justification from the Supreme Court ultimately again?
I think that's right, but I also think that the Supreme Court doesn't have the last word. Never has, never will in a democracy. The people get the last word. And affirmative action has worked. And I think whatever the Supreme Court says, universities are going to use it. They may use it surreptitiously, they may try to hide what they're doing, or they may do it more openly. And I think that's what this decision was about. Do you do it openly, or do you try to come up with justifications that may allow the Supreme Court to affirm you, but are less honest? And Ginsburg said the most honest way of doing it is to say, look, we want to have 13.5% African Americans and 7% Latinos and 2%, whatever it is. I think the American public isn't ready for that, because
right.
That sounds like quotas. And so, and it's interesting that a Jewish justice, Justice Ginsburg, who herself was probably subject to quotas, because she's my age. And, the old joke at Yale, Yale has a Hebrew motto, Urim v'tumim. And when I went to Yale, the joke was, if you can read it, you can't go there. Because they had a quota against Jews. It was like a 7 or 8% quota. So Jews historically have been allergic to quotas. And it's interesting to see Justice Ginsburg essentially coming out in favor of quotas, although she doesn't use that term and doesn't say so.
Let me ask you, for time's sake, let me skip to the George Zimmerman trial. I don't know if you heard the opening arguments today, the opening statements. The prosecution started with a tape that had bleeps out of it, saying that it was the 911 tape, and it was the portion where George Zimmerman said that these blanks always get away with it, and they said that George Zimmerman did not have to shoot Trayvon Martin. He chose to shoot, and then the defense opened with a nonsensical knock-knock joke. Knock-knock, who's there? George Zimmerman. George Zimmerman, who? Okay, now you're on the jury. I don't know what that meant. Do you have any? I don't know if you heard it, but do you have any feelings on what you saw today?
I can't believe that this lawyer O'Mara, who's a good lawyer.
It wasn't O'Mara. It was. It actually was Don West. Yeah.
Yeah. I don't know. You know, I think O'Mara is a good lawyer. This really sounds like a boneheaded decision. This is a murder case. The victim's family is sitting in the courtroom with tears in their eyes, and he's telling a knock-knock joke. I just don't get it. I mean, you know, if a student ever did send a moot court in my class, I would call the student in. And really ask them, are you in the right school? I mean, maybe you want to be a stand-up comedian or an entertainer. And by the way, if you do, come up with better jokes, with better material. The only saving grace is that apparently nobody laughed. It wasn't very funny. But I don't get that. I mean, this is such a serious case. It has racial overtones. If you're the defense, you want to start out by showing that it doesn't matter who was in the wrong in the beginning. If there ever came a time when Zimmerman's head was being banged against the ground by a younger man on top of him, that he had the right to prevent his brain from being seriously injured, and if the only way he could do it is by using lethal force, he had the right to do that. You want to do it without even a smile on your face. You have to be so dead serious. You're the defense lawyer. You're standing between yourself and the defendant, and if the jury doesn't like you, the jury's not going to like the defendant. And everything in this case comes down to George Zimmerman's credibility, because he's going to be the only guy to testify that he was sandbagged, that he was blindsided, that this young man jumped him, and that he banged his head against the ground. There's no other witnesses to that. If the jury doesn't believe him, and if the jury thinks that his legal team is not taking this case seriously, it's going to hurt. So I just don't get it.
Yeah, I know. Listen, Professor, as always, a pleasure. And I'll, if possible, if they decide on the gay marriage issues tomorrow, I'll certainly reach out to you, and hopefully, if you have the time, you'll grace us with your presence again. But thank you very much.